Hello. Today I'd like to present an original argument for cruel and unusual punishment, Eighth Amendment violation for Fort Collins City Ordinance 17181, which is public property camping. So my intent is to provide an argument that doesn't piggyback on Robinson or Powell or Robinson and Powell, as in the Martin Boise case. Rather, something which takes advantage of Ingram Wright directly, and something which the Supreme Court, as noted in Ingram Wright 1977, said should be used sparingly. As an aside, let's talk about what sparingly means. Well, I don't know what the Supreme Court intimated when it said sparingly in 1977. That's 50 years ago, roughly speaking. Let's take a look at the two possible interpretations. One of them could be by time. In other words, occurring over time. Now, the throughput of Supreme Court cases is relatively constant. And that's actually a problem that our country has. Despite the fact that there are 7,000 cases per year that apply for Supreme Court attention, only 70 are seen each year. And over the years, this number has increased. So the relative number of cases presented to the court which are heard shrinks over time. Okay, what about the rate of law production in the country? Well, there was an attempt to count the number of laws in the country done fairly recently, and the conclusion was that it's just too difficult of a thing to do. So nobody actually knows how many laws there are in the country. Okay, so there are too many laws to count, essentially, although it's not uncountable. It's a finite number. It's a huge number. Okay, what causes the production of laws? Well, entities like states, well, first of all, there's the Fed, there's Congress and stuff like that. Now, the increase in production of law by federal lawmaking is probably a minor contribution to the overall increase in production of laws. I think that the biggest contributor is probably cities. Okay, what's going on with cities? Well, about 50 years ago, only around 60, I think it was 67% of the people live in cities. Now, 83% of the populace lives in cities. So people have been creeping from the suburbs into the cities. Cities have been growing. Perhaps the number of cities is also increasing. That, I don't know. But the population of cities is increasing. And the relative population of cities, that is the fraction of people living in the cities divided by the overall population, the overall number of people, is growing. Like I said, it's something like 83% today, up from around 67% 50 years ago. So what do cities do? They write ordinances, city ordinances. A reasonable assumption would be that the larger the city, the more ordinances are necessary in order to orchestrate the population into some reasonable semblance of civility. So, so the overall number of laws is increasing. So the word sparingly, as used in the case Ingram Wright, directly after the phrase, the third tier characterization of what can constitute Eighth Amendment cruel and unusual punishment violations, which is that Cruel and unusual punishment imposes substantive limits on what can be made criminal and punished as such. Something to be used, and this is something to be used sparingly, has, as noted previously, two reasonable interpretations. And I think that the introduction of a new argument that's independent of Robinson and does not piggyback on Robinson whatsoever would not breach this sparingly condition, even though it can be argued that the word sparingly is vague. But under either interpretation of sparingly, especially the latter interpretation having to do with population densities, coming up with a new argument would not violate this sort of general statement or pronouncement of the Supreme Court in Ingram Wright. Okay, so now part one, I suppose. Okay, so we're taking a look at Fort Collins City Ordinance 181, 17-181. What is this ordinance? It's a camping ordinance. It's a public property camping ordinance. And what it's aimed at is the homeless people in Fort Collins. It was created in 2006. It was created directly after a 20-year gentrification plan had been enacted for the city. And I think that it probably was created in order to hide the homeless population by, just sort of like manipulating them and moving around and getting them out of places however the city wants to. It's a powerful tool. So powerful that it's way unconstitutional. So let's look at this law. Okay, I'm just going to paraphrase here because this is not about Fort Collins City Ordinance 17-181. This is about cruel and unusual punishment in camping. So paraphrasing Fort Collins City Ordinance 17-181, Fort Collins City Ordinance 17-181 makes it illegal to camp or to knit somebody to camp or to pitch a tent. And it defines camping as such. Camping shall mean 1, to sleep, 2, to spend the night, 3, to reside or dwell temporarily with or without bedding or other camping gear and with or without shelter, or 4, to perform activities of daily living such as eating or sleeping at such place. Camping, excuse me, camping shall not include incidental napping or picnicking. Now, in this definition, such place has no meaning. Such place must be ascertained by looking at the previous paragraph, which is an introduction to the whole thing of 17-181, which makes it illegal to permit somebody to camp or to pitch a tent before defining what camping is. Excuse me, I have lung cancer. At any rate, and I have good days and bad days. So, all right. So now let's go to the cruel and unusual punishment argument. So I'm talking about an original argument here. There's a very simple way to piggyback upon Robinson here. And this argument is kind of esoteric. Some might consider it to be silly, but it seems valid to me. Now, okay, and this argument goes essentially, okay, the second clause, to spend the night. Let's look at what that means. Now, Fort Collins, the city of Fort Collins consists of only two places, public property and private property. There's no way to negate this notion that Fort Collins consists of two jointly inclusive yet mutually exclusive places. If you go into the zoning laws, you'll find that there are 26 zones, but there's no definition of public property or private property. So there's no way to refute this notion that the city consists only of public property and private property and nothing else. And there is no such places such that public and private property exists at the same moment, except for on the borders of these two regions. Okay, so if you're a mathematician, you can think about that, whether it's an open set or closed set, but we're not talking about mathematics here. Okay, so the simplest piggyback argument on Robinson is this. Clause 2 makes it illegal to spend the night. That means it's illegal to be in the city of Fort Collins during at least some small period of time during the night for each night of the year. Okay, we as homeless people, if we were homeless, we don't have the independent right to be on private property. There's a law, Fort Collins City Ordinance 1740, called trespassing, which makes it illegal for us to be there. We don't have the right to be there. If we are there, it's through the generous right to host of people who own such property. So we don't have the right to be on private property during the night. In Fort Collins City Ordinance 17181, through the clause B, spend the night, makes it illegal for us to be on public property during the night. Therefore, it's illegal for us to be in the city of Fort Collins during a small part of each night. Therefore, it's illegal for us to be in the city, to be doing anything in the city during a small part each night. Therefore, it's illegal for us to be addicted to the use of narcotics during a small part of each night. Now, the case Robinson v. California in 1962 ruled that making that this kind of law is unconstitutional. It's cruel and unusual punishment. The part of the law, the California law, that was ruled to be unconstitutional is the part that says it shall be illegal to be addicted to the use of narcotics. So the city of Fort Collins is making it illegal for us to be addicted to the use of narcotics during a small part of each night. Okay, that's a silly piggyback argument. That's not my main argument, but it piggybacks on Robinson in a kind of simple way. Okay, now let's get to the original argument, to an original cruel and unusual punishment argument for Fort Collins City Ordinance 17-181. Okay, now, there are 50 states in the Union, and in roughly 46 or 47 of them, it is animal cruelty to not shelter a pet adequately according to its kind. Now, there's an exception in Hawaii, but I found the legislation, and it was an accident. There's an actual book on animal rights law, which has quotation from the Hawaiian legislature, which assures me, I can look it up and show it to you sometime, that the legislative body of Hawaii wants their animals sufficiently protected from the elements through the use of shelter. The other state is Georgia. All other states make it animal cruelty to not provide an animal under one's care with sufficient shelter according to its breeding and kind and requirements like that. So they're stated in various ways. Oregon has the most highly protective of their animals. I think they have 30 or 40 animal protection laws, and such. The state of Nevada defines animals so loosely that even plants can be considered to be animals, etc. So it varies from state to state. I live in the state of Colorado, which defines an animal to be any dumb creature. However, arguing that this applies to people as well, obviously, is the first thing that one would think of, won't work. Okay, I mean, it just, so we shouldn't try that. So then getting back to the point, it is animal cruelty to not provide animals with shelter to protect them from the elements. Okay, animals have fur, right? Human beings do not. If it's cruel to an animal, it's cruel to a human being. So therefore, one can argue rather trivially that if it's cruel to an animal to not provide it adequate shelter from the elements, it's cruel to a human being to not provide adequate shelter from the elements. And it's also unusual. In the original sense of unusual emanates from the English Bill of Rights in 1689, and it meant illegal. And that meant something that the judiciary wasn't able to enact or rule upon because it didn't have the proper jurisdiction to do so. And such was the case with the scoundrel Titus Oates. When the hanging judge removed his clerical robe illegally, that was up to the ecclesiastical courts. And so the Parliament, when the old king died, and it presented the English Bill of Rights after some other document, I think it was around March of 1689, and it had the cruel and unusual punishment clause in it. And that was adopted by the United States with almost no change of meaning except for the third tier of Ingram Wright, 1977, which is that cruel and unusual punishment imposes substantive limits on what can be made criminal and punished as such. So the burden of the state to protect its citizenry against unreasonable punishment switched from the role of the judge to the role of the legislative body of the United States when that happened. So getting back to my argument, okay, the punishment mentioned in cruel and unusual punishment, I call it Calp 8 of the Eighth Amendment, is always post-convictive punishment. And what we're talking about here in camping is pre-convictive punishment. And it's not enacted by the state, it's enacted by people. There's one simple government system model, which is you have the state and you have the people. So envisioning this model, we have the state and we have the people. And so civil order is imposed by law. The people obey the law, and that enables a kind of tentacles of order to permeate throughout society in such a way that society becomes a more intelligent entity than each of its nodes. The nodes are the human beings, in the government seat, etc. It can be looked at that way. That's sort of a naturalistic way of looking at it. If you Google something called the Wood Wide Web, you'll find that plant life is much more intelligent than we had originally thought. That there's a system of fungi which connects plant life. And for example, if we look at mimosa, a field of mimosa plants, if a bug bites a single mimosa leaf, the leaf will close in on itself. Well, if this fungal system, the Wood Wide Web, is in place, you can have one plant here and another plant there. A bug will bite this plant. It will close in, not to eat the bug, not like a Venus flytrap, just to protect itself. It does this by removing water from its limbs. Well, there's this message is signaled through the Wood Wide Web, and other plants will close their leaves too in response. Well, that's sort of what laws are like. Laws are they're imposing order upon a society that otherwise wouldn't be. So it's orchestrating the public in order to enact some sort of legislative purpose, right, in order to make society a more intelligent, cohesive, and well-ordered thing. Okay. Anyway, so the punishment in cruel and unusual punishment is post-convictive. However, laws can punish people much more severely than any post-convictive methods. If people just obey the law, comply with the law, they could end up quickly dead, very quickly dead. And it's up to the government not to write such laws. That's the whole point of the third tier here, right, of Ingram right. That's why such laws are cruel and unusual punishment. One example of this could be, we have speed limits where it's illegal to go faster than a certain speed. Well, if you have a speed limit which is illegal to go slower than a certain speed, and you make it, say, 100 miles an hour everywhere, a lot of people will quickly die on windy streets in suburbs and cities and stuff like that. So that'd be an example of the government orchestrating the public to kill itself. Just like now, camping laws are the same. The government is orchestrating the homeless people to kill itself because it's not allowed to use shelter. The homeless people aren't allowed to use shelter to protect themselves from the elements. It gets really cold here in Colorado. It was 10 below one night 2 weeks ago. All right. So anyway, so if it's illegal to make a law which is, people must adequately protect their animals from the elements. Well, they ought to be able to protect themselves from the elements. And yet, Fort Collins City Ordinance 17-181 denies them this right to protect themselves from the elements. So this law is cruel. If it's cruel for animals, it's cruel for human beings. It's unusual. It's illegal. It's unconstitutional. We haven't proven that yet. That's the point of this tape. All right. Although I guess we did prove it through the piggybacking of Robinson in that sort of esoteric way. But anyway, I want an original argument here. So, all right. So my claim is that, all right, our whole society is glued together by these laws that the government ought to be restricted from imposing plights or courses of action or acts, imposing forced acts upon the public pre-convictively at the same rate that not the same rate, the same. If an act is post-convictively disallowable, it ought to be pre-convictively disallowable. So, for example, the government cannot impose torture upon people who are prisoners who've been convicted of a crime. So the government ought not to also write a law which requires people to torture themselves. If you go to Wikipedia and look up torture methods, you'll find that exposure to the elements is actually a torturous method that's used in the past. It's just to expose people to the elements. So exposing people to the elements is torture, requiring people to not shelter themselves and be exposed to the elements because they have no other place to be. That's also torture. That ought to be restricted from having been legislated by the Eighth Amendment, by the third tier, by imposes substantive limits on what can be made criminal and punished as such. Ingram Wright, 1977. Okay, so if it's cruelty to animals, It's cruel to human beings. I think that's the essence of my argument. So I'm not using status. Now, Robinson used a completely different argument, but my argument is particular to um, the ability of a human being to shelter oneself and save one's life um, when the elements are going to do serious bodily injury or harm or kill them. Um, and that's almost everywhere in the United States, like probably in the same proportion that the animal rights laws exist in the United States to protect animals from their owners not protecting them adequately from the elements. So I don't know if this is sufficient detail for this argument, but this is an independent argument. It's about time that a new argument exists. The case Robinson, Robinson versus California, the law, it shall be addicted to the use of narcotics. It is so harmless. It's such a minor thing when you compare it to a law which makes it illegal to sleep, spend the night, reside or dwell temporarily, or to perform activities of daily living in public places. And it also does so in private property, vis-a-vis 17182A, and also forgets a home interior exclusionary clause. So it makes it illegal for people in the city of Fort Collins to do it in the curtilage of their property. Not only that, but within their home interiors for more than 2 weeks a year, unless they get permission from the city, in which case they get an extra week. And then they can get permission from the city again for another extra week. And then they've maxed out. So people cannot camp within their own homes in the city of Fort Collins for more than 1 month per year, according to Fort Collins City Ordinance 17182A. And then if you look at 17182B, you'll find that it's legal for people to camp in trailer parks and manufactured home escarpments throughout the city of Fort Collins, of which there aren't very many, which obviously gives rise to equal protection violations immediately. And that's under a textualist interpretation of this law. But this law has so many interpretations that a textualist interpretation is the right one. Right? Why? Because camping, as defined by the city of Fort Collins, has got to be ruled a technical term. Why? Because if you look up camping in any colloquial dictionary, it will say it's to occupy camp. What's a camp? A camp is something fixed relative to the ground. Okay, what's a camp in Fort Collins? Well, it's not defined. What is camping in Fort Collins? It's to exercise one of 4 verbs: to sleep, to spend the night, to reside or dwell temporarily, or to perform activities of daily living. Where? At such place. What is such place? Public property. What must camp be at Fort Collins? Well, it's got to be the place where camping is done. What is the place where camping is done in Fort Collins? At such place. What is such place? Public property. There's only one camp in Fort Collins. At least there are 2. There's private property camps and public property camps. But the entirety of public property consists of a camp, if you look at it that way. If you just look at it logically. Also, if you eat and drive down College Avenue is a road in Fort Collins. It's a major thoroughfare. Well, you're camping if you're eating and driving. Why? Because camping shall mean to eat. That's the first clause. And that's an exercising a verb. Where? At such place on public property. Driving and eating is camping in Fort Collins. So camping is not something that's fixed relative to the ground. in Fort Collins. Why? Because the city, the way it defined camping, defined it in such a unique way that it's unlike any other camping law that I've ever seen. The city of Denver defines camping vis-a-vis camp, as in colloquial camping. So it's fixed relative to the ground. The city of Boulder borrows the city of Denver's, and then there's some slight modification due to Denver having modified its original because it's so unconstitutional. Because it defines shelter to be anything that's not on your back. If you're wearing a hat, it's shelter. A book bag is shelter. And then it made it illegal to use shelter because that would be camping. Okay. But at any rate, camping occurred at fixed GPS points in Boulder and in Denver, but not in Fort Collins. If you look at it, just in terms of what the words say, apply them, and don't add just a textualist Supreme Court interpretation, the use of textualism for this law, because otherwise it's impossible to know what the hell this law means. Nobody has fair notice, not even the judiciary, because there are so many possible interpretations. Okay, so I'm kind of rambling now, but that's my original, and it applies not only 1791 here in Fort Collins, it should apply to many other camping laws. It's just an original argument. It doesn't piggyback on Robinson or Powell or Martin Boise or Jones or Pottinger or any other, case. And, well, it's a pretty obvious, I mean, it's like, I think it's a good argument, right? Thanks. Have a good day. Bye.